through Zoom or through some other mechanism, all right? And I just got the defendant's opposition, which I briefly had a chance to look at. So let me first start with my understanding of what this case is about, Attorney Love. The governor issued some press releases. There were going to be some changes to the eligibility requirements under the law. Yes?
Correct.
And it's your argument that those changes procedurally needed to go through the Administrative Procedures Act for a new regulation.
Correct.
And had to comply with the proviso in the line item in the budget.
Also correct.
All right. So the defendants have just indicated that that the department has authorized an emergency regulation. Are you aware of that?
I am aware of that, Your Honor.
Okay. I will hear from you with respect to that, I'm sure, in your argument. But do the plaintiffs concede as an initial matter that the policy choices being made here are permissible under the statute?
So we haven't briefed that specific question, Your Honor. We're focused arguments on the procedural questions at issue, and so that those we're not making that argument as part of either of the two counts in the complaints.
All right, so you're not making any argument about the substance of the policy decisions or the new regulation?
As to whether or not they comply specifically with the right to get the...
with the statute?
Correct.
Okay, so it's simply just the procedural arguments?
That's correct, Your Honor.
Okay, so I'll hear from you, and then I'll hear from counsel for the defendants.
So first, Your Honor, just as a preliminary matter, I would just like to say that we are going to focus our argument today specifically on count 2 in light of the emergency regulations which you just mentioned. Those have significant ramifications for count 1, so we're going to focus our argument today specifically on count 2.
Well, then let me ask, are you conceding that the emergency regulations were validly put in place under the Administrative Procedures Act?
So, Your Honor, those were just issued this afternoon. We have not had a chance to review them, but because they were issued this afternoon, we're going to focus our argument specifically on the 90-day notice mandate.
Okay, go ahead.
So, Your Honor, thanks for accommodating the hearing on such short notice. We're here today because starting tomorrow, defendants will end their long-standing policy of providing immediate shelter to homeless women and children under the state's right to shelter law. In the absence of immediate intervention by this court in the form of a temporary restraining order or preliminary injunction, homeless families with children will be denied immediate shelter placement and left out in the cold. At a minimum, we're asking for a temporary restraining order to preserve the status quo until the court can schedule a full preliminary injunction hearing. By way of background, on October 16th, Commonwealth officials announced that defendants would be imposing an artificial cap on the number of units in the state's emergency shelter system. This fundamentally alters the nature of the right to shelter in the Commonwealth. Prior to the implementation of the cap, the defendants have consistently added new units to the shelter system as needed to meet shelter demand and give eligible families immediate shelter placement. With a cap in place, the shelter system will fill up imminently, the defendants have predicted by possibly the end of the week, and families will then be placed on a wait list. Given the emergency nature of the shelter program, this is a lot like the fire department creating a wait list for families with ongoing house fires. Delay in emergency services amounts to the denial of services. And defendants are doing all of this in direct violation of a legislative mandate requiring them to provide 90 days notice to the legislature before making any changes to the shelter program that would restrict access to shelter benefits. The mandate appears in line item 70040101 of the fiscal year budget for 2024.
And would you agree with me, Counselor, that the purpose of that proviso is to give the legislature the opportunity to increase appropriations for purposes of the right to shelter law, should it choose to do so?
I would agree with that, Your Honor, yes.
Okay, and so would you agree with me that the legislature has been made aware of the problems that the Commonwealth is facing?
The legislature has been made aware of the problems that the Commonwealth is facing, however...
And has not increased appropriations?
Not in this budget year, I don't believe so, Your Honor.
All right, is there any other purpose in your mind to the proviso, other than to give the legislature the opportunity before any changes to increase the funding?
I would say so, Your Honor. So the SJC has analyzed a nearly identical notice proviso in a case called Wilson versus Commissioner of Transitional Assistance. And there the SJC stated that the purpose of these kinds of notice provisos is to alert the legislature to any reduction in benefits under the Emergency Assistance Program, right. Quote, the slightest of which could have dire consequences for recipients, end quote, and, quote, allow the legislature the opportunity to avert such consequences by making supplemental appropriation. So the only purpose is not just to alert the legislature, but also to protect the beneficiaries of the program from a reduction of benefits engaged in by the agency.
Right, although in Wilson, they did comply with the proviso at issue, correct?
Correct.
And in Wilson, in addition to alerting the legislature, it was to provide the legislature the opportunity to provide more funding if the legislature chose to do so.
Yes, but the legislature specifically included the proviso here so that if there was a reduction of benefits, they would have the opportunity to either respond with a supplemental appropriation to make sure that there was no reduction of benefits in a case where there was a budget deficiency, which I believe the Commonwealth is arguing that there is here. But to get back to your earlier question, Your Honor, the 90-day notice requirement has not been met.
Right.
There's no formal report justifying the changes. There's no formal report making a finding from the Secretary as far as we're aware that there is a budget deficiency. The Commonwealth may be arguing that in their papers, but as far as we are aware and that we have seen, no formal report has been filed with the legislature to that effect.
All right. So do you have a standing issue?
I don't believe so, Your Honor. So this gets to the declaratory judgment statute and the standard for standing under that statute. So the plaintiffs have to show harm or imminent danger of harm to a legally cognizable interest. Here, the defendant's emergency regulations take effect. Plaintiffs and those similarly situated will be harmed by a reduction of benefits under the emergency assistance program, including having to wait for shelter, and I believe, although again we haven't had an opportunity to read the regulations thoroughly, but a shorter allowable time span in shelter. I think there's a new restriction on the duration the families will be allowed to stay in shelter, which I believe is a reduction in the level of benefits in the regulations. And so that's a harm to a legally cognizable personal interest. Under the declaratory judgment statute, there does not have to be an explicit private right of action in the relevant statute. Plaintiffs just have to show that their injuries fall within, quote, the zone of interests, unquote, arguably protected by the statute. That's Enos versus Secretary of Environmental Affairs, that holding, Your Honor. And so here
Is that case in your papers?
It's going to be in our reply brief that we're going to file in response to the opposition, Your Honor.
Are you going to address in your reply brief the emergency regulations as well?
Not on the substance, Your Honor.
Not on the substance. What's the citation for that case? Do you have it?
Yes, Enos versus Secretary of Environmental Affairs, 432 Mass 132, 2000.
And was that a case involving a declaratory judgment claim and standing?
Yes, Your Honor.
Okay.
And so here, the 90-day notice provision is meant to protect program beneficiaries from a reduction in benefits without giving the legislature time to intervene. Plaintiff's injury here, a reduction in benefits, clearly falls within the zone of interest arguably protected by the notice mandate. And finally, Your Honor, there's an actual controversy here as to whether the defendants have followed the legal requirements needed to implement the emergency regulations.
So in essence, your argument is, given that proviso, the department cannot act unilaterally. It must act in connection with the legislature. It must provide that 90-day notice, see whether the legislature increases appropriations or not, and then proceed with any changes, emergency or otherwise, to the regulations.
That's correct, Your Honor. Like I said before, the purpose was not just 90 days. The purpose was to protect program beneficiaries from a unilateral reduction of benefits.
All right, anything else you want to make sure I understand?
I don't think so, Your Honor. Thank you.
Thank you very much. Assistant Attorney General Parr,
Yes, thank you, Your Honor.
can you tell me, it's too much for me to read in 6 minutes, what changes are made in this regulation?
Understandable, and thank you for accepting our opposition.
Oh, I should ask, does anybody have any objection to my endorsing the emergency motion of the ACLU to file an amicus brief as allowed?
We
No?
do.
Okay, I will do that, and they'll be docketed. Go ahead.
The emergency regulations are attached as Exhibit A to the package, and they do two things. The goal is to provide flexibility for the Secretary to respond to this incredible and unprecedented surge in demand for the shelter system and the resulting deficiency in the line item appropriations. So they're intended to apply only temporarily. Step one, the Secretary has the authority to declare, based on the facts and circumstances in the Commonwealth and in consideration of the line item appropriations, that I don't have the language in front of me, that the shelter capacity is not sufficient to meet the ongoing demand. And so once that declaration is made, and it has to be in writing, and one has been made today, it's attached as Exhibit B, then the agency has authority to take additional actions. And these are all grants of authority, they're not requirements, so I do want to correct that misimpression. After a declaration is made by the secretary, the agency is then required to issue written guidance explaining what it plans to do and the steps it will take to address the deficiency and the capacity concerns.
And
Among
where
those-
is this declaration, where is this authority coming from?
That is in the emergency regulations.
Okay.
And one has been issued today, it's in Exhibit B.
No, I know. Okay, go ahead.
And so that's in the, yes, exactly, sorry.
That's right.
And so, again.
So you're
within
saying
the-
once the secretary makes that
Yes.
declarations, she can go forward, He
He.
can go forward and issue the written guidance and the emergency regulation.
Then and only then, correct, can the agency take steps necessary to address the matters addressed in the declaration. And among those are 3 options specifically authorized in the emergency regulation. Those are, by necessity, placing a cap on the number of shelter units that the agency will be. I should have just pulled this up, to be honest with you, and I apologize, Your Honor. I was trying to go off memory, but that's probably not the wisest thing to do here.
Is it a 7,500 family cap?
I'm actually not sure if that's not in the regulations themselves, because the regulations truly are meant to respond to the facts on the ground as they change. So they are meant to be flexible.
So they permit
They permit.
the secretary to have a cap on the amount of housing, but not necessarily consistent with the press releases that we've seen and the numbers that were attached to the complaint.
That's what's intended for this particular emergency.
Okay?
And let me just step back, and I do apologize for possibly muddying this, Your Honor. But again, now that I'm looking at the text, the department has the authority to issue written guidance addressing how the department will prioritize families for access to shelter, whether the department will establish a shelter placement wait list, and policies and procedures for doing so. And only after notice, a 30-day notice period, the agency has the authority to set a limit on or establishing the time frame during which a EA shelter eligibility determination shall remain in effect.
So you're telling me that everything is essentially stayed for 30 days regardless?
Only with respect to imposing a durational limit on time and shelter,
Not with respect to the cap?
not with respect to what's being framed as a cap, yes.
Okay.
And so what I can tell you and what happened just, I believe, on my way over here today, is that the agency did in fact issue written guidance implementing, as far as I understand, a system for prioritizing families for access to shelter and establishing a shelter wait list. And I believe at the moment the capacity is planned to be 7,500. That has not been met today as far as I know. I think it will probably be met by the end of the week.
Okay. And it's your position that having gone through this process in compliance with Section 2 of the Administrative Procedures Act, that is proper and appropriate and can be in place for up to 90 days before the agency would have to go through a notice and public comment period?
I believe the notice and public comment period has to take place during those 90 days, but yes, Your Honor, the APA authorizes the promulgation of emergency regulations, and the Secretary acted under that authority today. It also fulfilled the 2 requirements for doing so. If you look at Section 2 of Chapter 30A, the agency is required to explain the rationale for proceeding on an emergency basis, and that appeared in the filing form with the emergency regulations today. It's in the package of exhibits. And the regulations, the statute also provides that the regulations go into effect immediately and remain in effect for only 90 days unless the agency proceeds through notice and comment. The agency is doing that. The notice and comment period will be open until December 1st, I believe. And the plaintiffs or any other interested parties can make use of that notice and comment period to share any concerns they might have with the agency.
All right, so
But
let's turn to this proviso then. I understand your argument, which is we've gone through the requisite requirements to do an emergency regulation. I understand that plaintiffs might respond to that in their reply. They have not had a chance to look at the emergency regulation, but they're still pressing that the department should have complied with the proviso and provided all the materials to the legislature? 90 days in advance of any, I think the language in the proviso is any amendment to the regulations.
To start with the facts on the ground, this is no surprise to the legislature or to the people of Massachusetts. The executive branch has emphasized the financial constraints and the acute spike in shelter demand many times in recent months and weeks. If you look at the public record, you'll see the governor issued a state of emergency because of this crisis in August 2023. The governor set up an incident command to address this. The legislature is presumably aware of all that. And even if they were not, in September, the governor filed a supplemental budget specifically requesting $250 million in additional funds to support family shelter and related services.
So is it your argument that satisfies the proviso, or that's evidence that the legislature was well aware of what was going on? Which one?
It's evidence that the legislature is well aware of what's going on.
Which I take you at your word. I'm sure the legislature is well aware. Why not send the information over consistent with the proviso and give them 90 days to take action?
Two responses to that, Your Honor. One is that there is a question as to whether or not, and we go into this in our brief, it's not our primary argument, but there is some debate about whether or not the notice provision applies in these circumstances, both in terms of the particular action the agency is taking, but more importantly, because we're in a time of deficiency. So plaintiffs are drawing the court's attention only to the 90-day notice provision, but we urge you to look at that provision and the one immediately before it. Both of those are quoted in our brief, I think around page 10. So the first proviso relevant to this inquiry is that in the event of a deficiency, nothing in this line item shall give rise or shall be construed as giving rise to an enforceable right or entitlement to services in excess of the amounts appropriated in this item. The next proviso is the one plaintiffs rely on, which directs the secretary to provide 90-day notice to certain legislative officials prior to implementing certain changes. Read together, these show that the plaintiffs lack standing to pursue the 90-day notice requirement. First, the notice requirement itself only creates a duty to the legislature, not to the individual plaintiffs, and there's no suggestion that the legislature intended to confer any specific rights upon individuals affected by the underlying policy changes. We also cite the Enos case that plaintiffs raised today, and we actually think it supports our position that when you're considering standing, you have to look specifically to the area of concern of the legislative language in play. So this is not about general provision of shelter benefits and preserving benefits for families needing shelter in the Commonwealth. It's only about notice to the legislature. More importantly,
well, is that consistent with Wilson, though? Wilson, the discussion in the SJC's case in Wilson about the purpose of these sorts of requirements being to give the legislature an opportunity to act, which one would presume it would be to act in order to provide the necessary funds.
I don't think so, Your Honor. Wilson didn't involve a situation like this, and it expressly says that the purpose is to alert the legislature, and that has effectively been done here, and the legislature has had time to act through the request for the $250 million, and it hasn't, correct.
And that was in a supplemental budget request in September?
It was, and the cover letter to that request specifically highlighted the unprecedented circumstances that were happening in the EA program, the demand in shelter placement requests, and obviously inherent in the nature of requiring additional funds, the concern that the funds are being depleted.
And how much was requested specifically for this program?
$250 million.
250, okay. And do we know, I mean, you know, I don't know, what the response was, if any?
As far as I know, there wasn't one. There's not been any official action on the request for this up. I do know, and it's explained in the affidavit attached to our opposition, that the legislature and the administration really worked hard to set the appropriations at the beginning of fiscal year 24 at a level that would address the anticipated capacity. Going back in time at the beginning of the year, when the budget was being put together, all projections suggested that the shelter caseload for fiscal year '24 would be around, I think, 4,100 individuals. That has exploded. It's now at around 7,300, and it keeps going up and up and up. It's unrelenting. So the existing appropriations of, I believe, $325 million was intended to serve almost, about half of the people who are in the shelter system now.
And does the
So-
regulation the emergency regulation that was passed, does it differentiate in any way with respect to the eligible families, other than prioritizing them?
I'm not sure what you mean.
In other words, does it change the eligibility requirements otherwise?
It does not, Your Honor. It does nothing to change eligibility requirements. And I do want to be clear, there's a distinction between eligibility for emergency assistance family shelter and placement in that system. What's happening here now only has to do with placement. A family still has to satisfy the existing eligibility requirements set forth in regulations.
Right, and that's not been changed.
It has
You
not.
just, once they get over that hurdle, this emergency regulation, and I will look at it in detail, permits the department to prioritize and create a wait list and perhaps limit the duration, but that's not until 30 days out.
Correct, Your Honor, and all of that is well within the Secretary's discretion, and it's incumbent on the Secretary to take action here in the face of this deficit. Again, as explained in the paper, where we are today is that there's about 7,300 families in the shelter system. Even assuming that number remains the same, which is not going to happen in reality, by the end of the fiscal year, the agency will have run through the $325 million that it's appropriated and an additional $210 million. So there's a real projected deficiency for fiscal year '24 that is motivating all of this.
All right, so your arguments with respect to the budget and the proviso is the legislature knows full well, was asked for a supplemental budget with respect to this program, that it failed to act at that time, that the plaintiffs do not have standing here to enforce it because they and other class members have no right to the program. Anything else?
Yes, the third piece, Your Honor, is that provision that I cited at the top of this discussion that addresses what is meant to happen in the case of a deficiency. And so under that provision, the legislature purposefully extinguished any rights that may arise under the line item in the case of a deficiency. Here, even assuming that the 90-day notice proviso establishes some duty.
Yeah, so you're saying that immediately preceding portion that says, in the event of a deficiency, nothing in this item shall give rise to or shall be construed as giving rise to any enforceable right or entitlement to services in excess of the amounts appropriated. You're saying that was the legislature's attempt to make clear whether or not the 90-day notice requirement is satisfied, that if the money runs out, the money runs out.
Correct, and that applies not just to the 90-day notice requirement, but the 90-day notice requirement to the extent it creates any conceivable duty or right that the plaintiffs may assert are subsumed in it.
Okay.
And so once the money runs dry, there's also no cause of action under this provision. And significantly too, Your Honor, at the end of that provision, the legislature specifies that in the event of a deficiency, individuals have no entitlement to services in excess of the amounts appropriated in this item. That falls in line with well-established traditional principles that state agencies can't expend funds beyond their appropriations. And so one way that we should look at this, plaintiff's request won't maintain the status quo. Plaintiff's request will require the agency to continue adding new shelter units, to continue adding, bring additional families into the system, and unfortunately, there's no money to do that right now.
And how do I know that?
From the affidavit attached to our exhibit, attached to our opposition.
Well, except for the money appropriated was supposed to last for 4,100 placements throughout the entire year, right?
Yes.
And so what are you telling me in terms of the amount of funds available right now for emergency placement?
right now for emergency placement, we're projected at a deficiency. So
Projected
right now there's
when?
Oh, I understand, Your Honor.
Yeah, when?
My
You have
apologies.
money right now today.
My apologies. Well, right now, if the agency's required, as plaintiffs want them to be, to continue operating as they had been in placing and finding new units for everybody who enters into the system on any given day, the money will drive much more quickly. I'm not sure I have the precise number of when that will happen, but it's impactful to say that if you could freeze the number of the caseload as of today, which is around 7,300, and will be at 7,500 by the end of the week possibly, that would only there's only enough money to bring that number of families and to sustain that number of units through the end of the fiscal year, assuming that we get a supplemental appropriation. And there have been commitments of the $325 million in the original appropriation, as well as a gap of $200 million.
Right, I guess what I'm trying to figure out is if we were to put a short stay in place, for example, to allow the plaintiffs to deal with this regulation, the emergency regulation, and perhaps bring forward any arguments they might have that it doesn't satisfy the APA or is insufficient. If we put that in place, what period of time are you telling me that the agency will run out of money, period, full stop, given the influx that currently is happening?
I'm sorry, Your Honor, I don't know if I can estimate that precisely, but what we can say is any delay in implementing these measures will drive the line item further into deficiency.
But it's not currently in
Because-
deficiency. I know I'm
It
talking
is-
about
I know,
dollars and cents.
What's that?
I know I'm talking about money.
Yes, exactly. So, as I understand it, and as best I can say today, the way the program is operates, of course, is that they have to procure spaces they have to procure units for the families that are in the system.
Mhm.
As I understand it today, the commitments that have been made to bring about 7,500 families, to keep them in place in shelter through the end of the fiscal year.
Is the budget.
Total, $325 million, it is the budget, plus an additional $210 million. So it may seem as though, put a pause on this, wait another week or two, but given the number of people who are entering the shelter system each day, which seems to be between 20 or 50 families each day, that'll add up very quickly, and it's very expensive to find these units and to shelter these families.
I see.
And
So what you're saying is the amount of the current appropriation plus $210 million is what it would take for 7,500 families through the end of the fiscal year.
That is how I should have said it, Your Honor. Thank you.
Okay, all right,
Yeah.
I got it. Go ahead.
Exactly. I think we've covered what I would want to cover with respect to the 90-day notice provision. Because we're here on a preliminary injunction, I do want to flag that's enough, and because there's no likelihood of success in the merits, the court can and should deny the plaintiff's request for a preliminary injunctive relief. But I also do want to flag, as we say in the brief, that the balance of the harms and the public interest really weigh against granting the injunction. This isn't about maintaining the status quo. And while the administration and the defendants are very sensitive to the impact that these regulations will have on families in the Commonwealth, they're also constrained by very real financial constraints, not to speak of the constraints of identifying shelter units amid the housing crisis, the shortage of affordable housing in Massachusetts. So putting that all together with principles of separation of powers, administrative law, the agency can't keep spending and driving the line item into further deficiency, and the court doesn't have the authority to order it to do that.
All right, I appreciate that. Anything further?
Just to say, we may have 2 additional affidavits in support of our position from the Executive Office of Housing and Livable Communities, and so we more than likely will file those later today. And
Okay,
Yeah,
all right.
thanks.
Attorney Love, anything that you want to respond to with respect to that argument?
Yes, Your Honor, I'd like to just respond to a few specific points. So,
course.
with regard to the budget deficit conversation, I just want to reiterate that there still has been no specific finding by the Secretary that there's an appropriation shortfall. To the extent that that's in the papers, or that it's been mentioned by the governor sort of in passing or vaguely in the emergency declaration or wherever else, does not meet the requirements of the 90-day notice provision, which requires the Secretary to submit a formal report laying out the budget deficiency and to give the legislature an opportunity to respond specifically to that deficiency. That requirement still has not been met, as far as I understand the Commonwealth's argument.
Okay.
And then I just would like to respond regarding the other proviso that they mentioned. So I just want to point the court's attention to the last line of that first proviso that precedes the proviso that we rely on, which
Can I
is...
pause you for just one moment?
Please.
Because now I want to hear from Attorney Parr. So what he's saying is that in this proviso, the requirement that the Secretary put forward the determination to the legislature that available appropriations will be insufficient to meet projected expenses and the projected savings from any proposed changes hasn't been satisfied. That's one of the things that I was pressing you with respect to what is the actual situation on the ground with respect to dollars and cents. Is that made in the declaration and in the emergency regulation? Is that sort of statement, that determination that available appropriations will be insufficient to meet projected expenses? When I
Yes,
read,
Your Honor.
I will find it.
I'm not sure if it's couched in that precise language, but the declaration that the Secretary issued today, in line with the emergency regulations, makes that point clear.
Says what you just told me, that we're going to run out. Okay.
Yes, Your Honor.
All right, go ahead, Attorney Love.
And Your Honor, just sort of similar but related point is that this is the first time today the legislature is actually getting specifics of what is going to change specifically. The emergency regulation, it seems, based on what my sister counsel was saying, lay out the details of what's going to change, but at every point until now, they've only been laid out in sort of like vague detail. And apparently, my understanding as well is also that there is a lot of discretion left in the Secretary. That also is not giving the legislature's notice of the specific changes that are going to be made. It's telling the legislature that the Secretary has discretion to make changes, but it's not telling the legislator what he's going to do.
Well, what if they were to give that 90-day notice with the declaration and the emergency regulation to the legislature today?
If the legislature got that specifically and approved an appropriation based on that, then potentially, Your Honor, but that's not the situation that we have here.
Well, wait a minute. They don't have to approve an appropriation. They have to be provided the information.
That's right, but they have to be given 90 days, which hasn't happened to this point.
Okay, go ahead.
And then I just want to make a couple of points with regard to the first proviso that my sister counsel mentioned. So the one that comes specifically before the proviso that we rely on,
Yep.
I just want to put the court's attention to the last line of that proviso. It says that at the beginning, provided further that this item shall be subject to appropriation in the event nothing in this item shall give rise to or shall be construed as giving rise to an enforceable right in excess of the amounts appropriated in this item. So it doesn't say that there's no enforceable right. It's referring to the amount appropriated in the budget.
Yeah, but that argument would seem to say that they have to keep the regulations as are, continue as they have been until all the money runs out. In which case, rather than this process that's been put in place in terms of a waiting list and some prioritization, all the money has run out and everybody in placement would be harmed.
My response to that, Your Honor, is that this proviso operates in tandem with the following proviso that we rely on, which is that if that's the case, if the money is going to run out, the Secretary needs to give the legislature 90 days notice specifically of the funds, the amount of the deficiency, so that the legislature can respond. So they can't be read separately, Your Honor. They go together, is my point.
All right, anything else?
And then I think that I do have one other point I wanted to make. No, Your Honor, I think we're all set. Thank you.
All right, so you know the question I'm going to press you on, Assistant Attorney General Parr, which is, do you have 90 days before the money runs out with continuing as is? Do you know
No,
that?
Your Honor, if you were to, if that is what would happen, it would lead to a shortage in the back end, or it will just accelerate the moment at which the funds are entirely depleted, and then, as you said, nobody in shelter would be
Well, do you have 90 days? In other words, if the agency were to go to the legislature today and say, look it, we have forecasted this, if we don't cap this and put these wait lists in place, we're not gonna make it through the year. We're giving you the 90 days, but do you have enough money to get through those 90 days?
Your Honor, I think that's what's implicit in all that what's been submitted today and what's been submitted to the legislature and in the emergency regulations and in the declaration today. I don't think we've done the exact math, but 90 days, 20 to 50 new people per day, the cost of adding those people into the system, finding units for them, and maintaining current capacity, it's not feasible.
Yes,
And the
but do I have
agency
any
is-
evidence before me that tells me current operations as they are, projections as they are, when the appropriation will run out?
I believe
The
that's
current
what's in the
appropriation.
in share affidavit.
Which affidavit?
Sorry, the affidavit of Deep Bashir.
Okay, with your
From
opposition?
A&F. Yes, I think that will give the court the assurance that you're looking for. And also, where we started today is a question about, are we talking about procedure or substance? I think the two have been muddied a little bit, or the two overlap with one another. The complaint, though, is all about procedure, and that's what we need to think about. The agency is grappling with a budget deficiency that's established in the papers, and it's authorized and required to act in the face of that deficiency. It has to figure out a way to maintain whatever level possible of shelter placements while also not exceeding the budget. The projections for the year, and I'm sorry, I wish I could answer your precise question about today, tomorrow, next week, 90 days. I don't think we can do that. But I think the answer is that when you're forecasting out, there's not even enough money in the current appropriation to get through the end of the year with 7,500 families. That's why the supplemental appropriation has been requested, and the administration has not yet had a response to that. And that's why the secretary has to take these actions, and they're authorized to do that on an emergency basis under the APA. And the decisions that are reflected in those emergency regulations, which I understand plaintiffs' counsel are not challenging today, are reasonable and well within their discretion.
All right, you're gonna get me a couple more affidavits, you're gonna get them today or tomorrow. This emergency regulation goes into place when?
It's effective when it was filed, so it's effective today.
Okay. Attorney Love, you're gonna get me a reply brief with respect to the emergency regulation by when?
Yes, Your Honor, within the hour, hopefully.
Okay.
Yeah.
Well, then, it seems to me that I need to get you a decision by tomorrow, at least with respect to the temporary restraining order. You're telling me that you're not going to hit 7,500 tomorrow.
As I understand it, it will more than likely be I'm not sure if it's tomorrow, but this week is anticipated.
All right. Anything further?
Just one last point, Your Honor. So just with respect to the compliance with the APA, the proviso that we rely on specifically says that notwithstanding any general law or special law to the contrary, not less than 90 days. So even if there is compliance with the APA, with the emergency regulations, that does not absolve the Commonwealth, the Secretary, of his responsibility to comply with the 90-day notice requirement.
All right. I mean, I understand your position. I can read that proviso. What counsel is telling me is that's a fight between the governor and the legislature, and not necessarily something that not something the judiciary should jump into the middle of, and not something that your clients have standing with respect to. So I think that's an important issue for me to decide.
Understood.
All right. Thank you very much. I will take this under advisement. I will look for those things. Could you please get Mr. O'Loughlin's email so that you can send them to him directly? And I'll get you a decision, at least with respect to this temporary restraining order, by tomorrow. Okay? Thank you.
Your Honor.